Good evening to all of you, and good morning to Lord Goldsmith, who's joining us from London. I'm sure there are members of the audience who are joining us from different parts of the world, so greetings to all of you. We have a very eminent panel today to discuss a topic of great interest to me personally and to a lot of colleagues and commercial lawyers all over the world that I know of. Our first panelist is Honorable Justice Sanjay Krishnan Kaul, Honorable Judge of the Supreme Court. No further introduction perhaps is required, but just to let all of you know that Honorable Justice Kaul was elevated to Delhi High Court as a judge, and thereafter he has served as Chief Justice of two of the most sort of bigger high courts in the country, Punjab and Haryana High Court, Chennai High Court, and Chennai High Court also is one of the chartered high courts, one of the few high courts which is at the forefront of commercial litigation. He therefore comes to this fireside chat today, bringing with him a wealth of experience in various high courts as an honorable judge and then as a judge of the Honorable Supreme Court. Our second panelist is Lord Goldsmith, QC. I have had the opportunity of working with Lord Goldsmith in several commercial disputes over the last decade and a half. Lord Goldsmith is former Attorney General of United Kingdom and is currently the chair of European and Asian litigation at Debevoise and Plimpton. Interestingly, just for the benefit of those of you who do not know, Lord Goldsmith has a substantial India-related commercial litigation practice and commercial arbitration practice. Our third panelist is Mr. Arvind Datar, Senior Advocate. Mr. Datar is a very well-known commercial litigation senior advocate, but primarily now focused on the areas of tax litigation and constitutional law. Mr. Datar is also an academician of sorts in the sense that he is a prolific writer, has written very respected textbooks on various branches of law and commercial litigation in India. He often appears as counsel in international litigation and arbitration matters, sometimes even as expert on Indian law. And last of all, it is me. I'm the junior most in this panel, but I practice as a senior advocate in Delhi and sometimes in Singapore and London. The focus of my practice is commercial litigation and arbitration. Just at the outset, the focus of the pattern or the format of our fireside chat is really not based on presentations by the panelists, but I thought that it might be very interesting if we started a flowing conversation between all the panelists who have their perspectives and they might want to ask questions to others who come and sort of bring their experience to today's panel. So without wasting any time, perhaps I think I should ask my first question to Mr. Datar to start this conversation or chat. And it is really about the features of Commercial Courts Act in India. And I wanted Mr. Datar to tell us what are the sort of essential features of the Commercial Courts Act in India, and how is the Commercial Courts Act making an attempt to improve our ordinary civil court system. And I thought that would be Mr. Datar's sort of enunciation or his reply to this question would perhaps lay the foundation of our follow-up discussion.
Thank you, Gaurav, and it's a privilege to be part of such a distinguished panel with Mr. Sanjay Krishnan Kaul. He was our Chief Justice of the Madras High Court, and Lord Goldsmith as well. We had the opportunity of participating in an earlier webinar which was conducted by you. As far as the commercial court system is concerned, I must mention that I had the opportunity of giving evidence before a parliamentary committee before this Commercial Courts Act was drafted. I think there is some. Yeah, when the Commercial Courts Act was prepared, there was a parliamentary committee headed by Dr. P.J. Kurian, member of the Rajya Sabha, and on behalf of the Madras Bar Association, few colleagues and I had given evidence at that point of time. And we are glad that ultimately the Commercial Courts Act became a reality, though it took some time. Now, for this talk, I did speak to lawyers from different parts of the country just to get a feedback of what has happened, how far the Commercial Courts Act has. Well, I got the almost uniform view that it is definitely a very, very important change for the better. Most lawyers, my colleagues, told me in different courts that what's most important is that the definite timelines are a very, very important development. There's no longer the old system where you could keep filing a written statement whenever you like. So definite timelines have been prescribed. There is a very clear consequences of what will happen if you don't meet those timelines. The system of costs has come in. Earlier, the limit was just 3,000 rupees or something, and Section 35 and 35A. So the cost system has come in. And what is also significant is my colleagues tell me that slowly and surely a culture is developing where you have to meet certain deadlines, you have to take the part. And so overall, it's an improvement. There are some points which are some people are not happy with. I'll come to it later. But barring one or two courts, I think overall people are happy with the system. In those places where people had some reservations, the main difficulty was the lack of judges, particularly in the High Court, where there were no adequate judges to deal with commercial courts as a dedicated court. So there was a court which was doing commercial courts as well as other matters. That's the problem. But to answer your question, overall, it's definitely a very important change for the better, and we must make sure that this experiment really works in the future. And talking of commercial courts, at that time we had a lot of when we did this presentation to the parliamentary committee, it referred to the Wolf Committee, and I'd like to ask Lord Goldsmith as to how the commercial court system evolved in the UK. And sir, I was just going through the website of your courts, and I find that the Queen's Bench division has not only a commercial court, it has a mercantile court, and the website shows that there's some technological court, there's a patent court, and so on. Whereas we have got everything clubbed together in the commercial courts. So I'd like to know, how did this commercial court system evolve in the UK? I mean, how is it developed? And how do you appoint judges? Do you have a separate selection procedure for the judges? I mean, are the judges in the commercial courts people who have already specialized in commercial law? And overall, how do you, what do you feel? Has it been a great improvement over the past as far as UK experience is concerned? Because we are primarily concerned with the UK experience and how it can be applied to India at a later point of time.
Well, thank you for the question. I hope I'm audible, being sitting in London, where we have a nice sunny day for the first time for some time. So that's a pleasure. I want to make a couple of preliminary observations. First of all, I'm really delighted to be on this seminar, this fireside chat. I wish I were doing it from India, where I would love to be. So the sunshine outside is the closest at the moment I can get to thinking that I'm in India, but I hope that the time will come soon because of the great developments in science that we will be able to travel again. I look forward to that. The second thing I want to say is that I think it's very interesting to compare the experiences of India with that of my country. But I have to recognize that India has far greater challenges because of the huge population. I've always been impressed, I say this to Justice Kaul, with the way that the Supreme Court of India handles some of those issues, such as public interest petitions. That's not really what we're talking about today, but I think we have to recognize that what may work in a small country, which comparatively England is, may not work in a larger one. And I've also, in the second observation is, and I've just talked about England, not the UK, and there's an importance in that because we have different legal systems in the United Kingdom. We have the legal system in England and Wales, the legal system in Northern Ireland, which is pretty much the same as England and Wales. It's a separate court system, but the law is generally the same. And Scotland, which still has some of its own specific features. And if you went onto the website to look at Scottish legal robes, you would find that they're very grand and even more elaborate than some of the robes that are worn by the English judges. But returning over to your question, the English Commercial Court goes back to 1895. That was when it was first established. And it was established in a very practical way. At that time, all commercial decisions and all decisions were divided either between the Queen's Bench Division, which dealt with contracts, with torts, the Chancery Division, which really dealt with trusts and equity matters, the Probate, Divorce and Admiralty Division, which dealt, as its name suggests, with wills, divorce, and Admiralty matters. It used to be called the Rex, Wives and Wills Division as a nickname. And the Commercial Court came about because the merchants of London were really disappointed with the way that their decisions were reached in relation to commercial cases. There's a famous case, my recollection is it's called the Rosebank of Australia, but that may not be quite right, which was decided by a judge called Mr. Justice Lawrence, who was an excellent man, but a rubbish, terrible judge. And he had to decide a question on general average, which is quite a specialist topic in Admiralty law. And he had the two greatest minds in that field appearing in front of him. And he took months and months and months to reach his decision. And when he reached it, he gave no reasoning worthwhile at all. He just announced that he agreed with one of the lawyers on one point and one of them on another. The case went to the Court of Appeal, where it was completely reversed. It went on to the House of Lords, where his original decision was upheld, but for entirely different reasons. And the merchants of London said, this is useless. This was an important case. And unless you do something about it, we are going to send all our cases to arbitration, where we can choose people who understand the disputes that we're dealing with. And that was the key point, that the judges needed to understand the commercial context and the commercial practices. You know, if you're having a case on bills of exchange, you need to know that's different from bills of lading. And there were some judges who didn't know that. So that was the start of the Commercial Court. It started really as a division. Actually, strictly speaking, it was a list. It was called the Commercial List, which meant that cases went to the Queen's Bench Division. If they were commercial cases, they were assigned to the Commercial List. Some of the Queen's Bench judges, at start only one, and then two, eventually it grew to 8, were assigned to the Commercial List on the basis that they were judges who, by their training and experience, were particularly equipped to deal with those cases. It has all changed a bit since then. Arvind, you mentioned the Mercantile Court. Those are actually provincial courts outside London. There's one in Bristol and there's one in the Northwest. They also deal with commercial cases, but they're a slightly lower level. And then we do now have a Technology and Construction Court, which is a specialist court. And it's actually now been reorganized a bit further, so that we now talk about the business courts. And that brings together people from judges from the different divisions who have experience of business. But the fundamental point is, I think what has made the Commercial Court a success has been the quality of the judges, because of their understanding of commercial issues. And I think that's important to business people, you know, for two reasons. One, obviously, you do want to have a judge who understands the commercial instruments and the commercial transactions that you're dealing with, because you don't want someone who's deciding an important question on a bill of exchange to be the first time he's thought what a bill of exchange is. But secondly, because actually the commercial transactions are complex, because there is an understanding amongst businessmen of the instruments and context in which they're being decided. And they're entitled to have someone who understands that deciding their dispute. And I think that's the fundamental question. So how did judges become to be judges of the Commercial Court? They are appointed as High Court judges, if we're talking about the High Court, or next rung down if we're talking about the mercantile courts. They are then assigned to that court these days by the Lord Chief Justice, who decides who are the judges who are best fitted for that particular division. And they will have been chosen for appointment with that in mind quite often. I can go on, that's a worry, and take up the whole of this fireside chat talking about judges' appointment, but let's move that conversation on. I mean, one of the issues that gives rise to, I suppose, is how you train commercial court judges. Well, as I've been saying, we do that because of the way that they've been brought up, the way they've been trained. And most of them, not everyone, but most of them will have been barristers practicing in the commercial courts. They will be Queen's Counsel, who will have made an expertise in commercial transactions. So they will then find themselves approached, or these days you have to apply to become a judge. But I'd be very interested to know, so I'm going to turn, if I may, to Justice Call, with how in India commercial judges are trained, if indeed they are. Is training given to those within the system? And when there is a question to be decided who should fill a slot, an opening on the bench, is commercial expertise or expertise in commercial law one of the things that's taken into account?
Good afternoon to everybody and the people who have joined in. Lord Goldsmith put, I think, a very pertinent question, because we are dealing in an era where there are complex and specialized areas of field, and lawyers are more and more specializing in a particular field rather than being a general practitioners all over. Now, undoubtedly, there is a correlation and a positive correlation between a country's judicial capacity in commercial laws and what is its quality of business environment. And our country has been endeavoring to look at how to improve the business environment. Now, what we call, or which is commercially called, the ease of doing business database is dependent also on how efficacious your judicial system is, which in turn depends on how much the understanding the judges have of the subject matter. The database of the World Bank relating to solving commercial disputes is said that it's 92 days faster in countries with specialized commercial jurisdiction. And such courts require specialized judges with experience and training at handling commercial disputes. So there can't be any two ways of saying that commercial courts were required and were needed. Question how well we can make it work. The 253rd report of the Law Commission suggested that judges of commercial courts should be persons with demonstrable expertise and experience in commercial litigation and be appointed from amongst the high judicial service. In fact, for that matter, I feel that in any jurisdiction should have people who are either have had opportunity to work in that field or are trained to work in that field. This proposal of somehow did not get translated into the Act itself, but Section 20 of the Act envisages that the state governments, in consultation with the high courts, should provide training to judges who may be appointed to the commercial courts. And that is something which must be initiated in an institutional fashion. So we have judicial academies which take this process further. But something which is a matter of concern to me is that whether we are getting people who are already specialized in the knowledge and expertise of commercial law as judges. As Lord Goldsmith said, that barristers and other persons join in. In India, it's not easy to persuade prosperous lawyers to come and join the bench. And especially at the subordinate judicial level, it's a great challenge. Leave aside the High Court also. Many of them have said no, including some present company. In my endeavor was not successful. So that's a great challenge. The people who understand commercial law are practicing on the commercial law side. Those who are practicing on the commercial law side don't think it's lucrative enough to come on the judicial side of the commercial side. Therefore, we are to some extent more dependent on training rather than getting them in. Of course, in some the metropolitan towns like Delhi, Bombay, Madras, Calcutta, the opportunity of getting people who are trained in commercial law, at least the high court level, exists. I'm saying that is also a challenge, but it is certainly we have been able to get people on the commercial side who with good practices at the bar who have come in and a great asset. But I think something which Gaurav can answer possibly is that how do you think, and this is a challenge I pose, how do you think that commercial lawyers will be willing to have judicial appointments in commercial courts? And what can be some kind of an international model which we may consider to follow or imbibe in our system?
Thank you very much, sir. I think, first of all, sir, I think there is a lot of improvement in the effort within our system to really attract commercial lawyers to come to the bench. And I think when I say this, I look at Delhi High Court, my own High Court, and I think that there is definitely an effort for a greater number of busy practitioners accepting the offer and sort of making a switch to the bench, which itself I think is a very positive sign. And some of them are contributing in a very contributing to the development of commercial law in a very appreciable manner, to say the least. But I think, sir, and sort of my suggestions come from a discussion that Mr. Datar and I had a few months ago. I think there is a lot of scope for innovation based on the procedure of appointment of additional judges or ad hoc judges under Article 224 of the Constitution. And I think it might perhaps be a good idea for a debate or a discussion to start on whether busy practitioners who are at a stage in their career where they would not like to give up legal practice to go and join the bench for the entirety of for the remainder of their career would be willing to make a sacrifice for shorter periods, let us say a year or two, to go to another high court and sort of contribute. It can be shorter periods in another high court. It can be a slightly longer period in the high court where they practice. But as long as the understanding and assurance is that they will be relatively free to give up the judicial appointment after they feel that they have sort of given back to the system in a year or two, and then they can come back to legal practice. I think that is a method, that is a mechanism that can be considered. And I have a feeling that a lot more busy practitioners would be willing to take a break from their litigation practice as counsel for a year and a half, and contribute to the institution as a judge. Do that fully with full energy, because that they would know that they are doing this for a very short period and they want to leave a positive impact, and then have the freedom to return back if they wanted to. Lord Goldsmith can tell us a bit more about this, but in England, for example, I see this system of deputy high court judges who are basically busy, often busy Queen's Counsel on the commercial side, who accept the position of deputy high court judges. It is a process of selection pretty much similar to high court judges. And then they have a commitment for an X number of days in a year to sit on the bench, unless I got it wrong. That's the way I understand it. There is another model that's, for example, which may be slightly sort of more adventurous from the Indian context, but in the Singapore International Commercial Court, they have a system, sir, where a judge really is asked to come and sit or preside over a bench on a case-to-case basis. So that judge would be free to do whatever they want to do in whichever part of the country. So I just wonder whether in a very high, just as an example, sir, in a very high value commercial dispute in let's say Chennai, in the Madras High Court, if somebody who's a busy practitioner in Delhi was asked to give up 2 months of his life, go and sort of preside over that bench and do that matter thoroughly as a judge. I think these are 2 or 3 alternative models that we can think of in terms of innovation. Right. And particularly because these models would allow us to use the resources available for bringing them on the judicial side without really making any permanent increase in capacity, in the sense increase in the number of judges. And I think these are suggestions or points for discussion that can be considered going forward.
Can I just intervene on that, because you mentioned Singapore and the English example. I mean, people do sit as deputy high court judges in England. I mean, I sat as one for some time. But that's a way of really just helping with the backlog of cases in the court. And it's also a way of seeing whether somebody has got the right judicial temperament. And if they sit as a judge and they're already shouting at counsel when they're a deputy, you really don't want to have them as a permanent judge. Singapore, I think, does something slightly different. It appoints people for a year, is my understanding, and maybe that's renewable, as a judicial commissioner. So that's the same as an ordinary judge, but just there, and the idea is to go back to practice. And the problem that gives rise to, I think, is if you're a litigant and you find that the person who's hearing your case is sometimes a judge, does that make them think that is, they're likely to get a different quality of justice, or that they're concerned about what the impact is so far as the other side is concerned. So there are some issues to give rise to, but it is important to get that expertise, I think. So I just want to.
I just want to mention one thing, sir. Just want to mention this. But I think this call can really seriously take it up, because we have been making this proposal that, and this about 9 years ago, 10 years ago, we had the proposal where, for example, suppose Bombay has a huge backlog of tax cases or commercial cases. Me practicing in Madras or somebody practicing in Calcutta was willing to give up 2 years of practice and go to Bombay. And then we give an undertaking that we will not take any brief from Bombay thereafter. So there's some kind of independence. And I was asked to speak to senior counsel. Everybody I spoke to said we'll give a practice for 1 year to 2 years. I think, why can't we try it as an experiment?
Mr. Datta knows this is a topic on which he has had some discussion with me also on that time. Personally speaking, the Singapore model would be very difficult to accept in India in the given scenario. If somebody comes for a case, the litigant will not accept it. It's my very clear view. There are two methods by which this backlog issue you said. One is, I have been saying there are provision in the Indian Constitution for extending the term as an ad hoc judge. Now, I've been saying if there are judges who are expertise in certain field, why can't be given a tenure of say 2 years more or 3 years more to sit at least on the backlog of that subject cases? And though we are talking about the commercial courts, my view is it can be criminal side, it can be service jurisprudence, capacity to do work, and some people are willing. Somehow we have not been able to, take this forward. Though it is a matter which is now, I would like to say more, because it's come up on the judicial side, to which I am part of the bench. Somebody moving a PIL in this direction. But I think one of the most important things Mr. Datta said, and which I personally feel is good, is if lawyers are willing to make sacrifice and go and practice in a court, in which court they will not practice again, I think this is an avenue which certainly should be explored. This period of 3 months and 6 months is very difficult in the Indian context with the volumes of cases. But I would say realistically a period of about 2 years is what is required. So somebody who's an expert in tax, say who's practicing in Delhi and Bombay, says, okay, I'll go to Orissa and sit as a judge for 2 years and do tax work. But a momentum has to be built both mentally to attune the legal system to accepting this, the lawyers also accordingly, and for the system to accept this. My own view would be both these are experiments which are worth taking.
I should just add, there's one other thing that we do in England, which might tempt people from the commercial bar to come to become judges, and that's that the senior judges, they're given a knighthood. So no one has ever done any empirical research to work out what that's actually worth in terms, but if you think about it, a commercial QC is probably earning at least £1 million a year, and the salary of a High Court judge is, I think, 189,000. So there's got to be something to tempt them to come from the one to the other. I think it may also be simply a different life, perhaps a slightly more stressful life. Litigation in court can sometimes be a rather younger man's game. I don't know. I say that, though I still do it all the time. I can't describe myself as young any longer. But there may be features, and obviously we also choose our judges for the appellate court and ultimately for the Supreme Court from the judges in the lower ranks. So there's the prospect that you might find yourself at that level and therefore making law, which is a great thing to do. As I'm speaking at the moment, can I ask you, Arvind, Mr. Datta, what do you think the strengths of India's commercial court system are at the moment? And is there any data to show that they've, as implemented in the high courts, resulted in a faster disposal of cases? Can you tell us about that?
Yes, actually it's a mixed answer. For example, in the Madras High Court, which is my mother High Court, so to speak, we have a happy situation of having a large number of judges, and without any trace of flattery, I can say that Justice Kaul is responsible for that. We have got a very large strength, and in some high courts, it's a problem. So the main answer I got was that wherever there have been a large number of judges, the commercial court system has worked. For example, I'm told in Madras there has been 3 or 4 judges who have been assigned commercial work on interlocutory matters and arbitration, Section 34 in commercial suits. And Whereas in some courts, what's happening is the same judge is having multiple responsibilities and doesn't really get time to get to the commercial system. So, but as I said earlier, by and large, the impression is that it's the system which is working. It's working for the better. The kind of time pressure which is working is there. For example, in the Arbitration Act, also the fixing of a time limit was 18 months, and there was a Gaurav will recollect there was a huge uproar of people saying, how can you even finish an arbitration in 18 months? But now people have accepted it. Yes, it's possible. So now timelines are there. So there's a lot of improvement. And I also spoke to some people in places other than Madras, Bombay, and Calcutta, which are not the charter high courts, which don't have the original jurisdiction, and the commercial courts are basically the district courts. Even there, I'm told that there is a substantial improvement. There are some district judges who are doing dedicated commercial work. In fact, I was told in Karnataka, they were a separate commercial court building also. So there's a huge change in that. Yes. And as far as the weaknesses are concerned, my feedback was that one is that there should be better training. Like when I was in the Madras High Court, whenever the district judges got selected, there would be a 4-5-day training program. And I remember I was asked to give lectures on company law and some trademark issues in those days. And one thing which I would also request Justice Kaul to kindly consider is that my colleagues have told me, sir, that one problem is the rules of uniform practice directions. For example, Section 18 talks of practice directions. No, I mean...
what are those?
No, there's no practice direction. For example, the Commercial Courts Act is basically a short act, and it makes changes in 3 sections of the CPC and 10 orders. But otherwise, the CPC applies. But my colleagues who are practicing on the commercial side almost exclusively, they said that if you have some kind of a uniform practice direction, rules, so to speak, which will be the same throughout. How do you compute costs? How do you arrive at the amount of costs? What about the payment of interest? In terms of other procedural matters, if there's some uniformity, that could go a long way in bringing some kind of stability to the system. Now, for example, there is other problem. The other problem is in Madras, they've reduced the pecuniary limit to 3 lakhs. It was 1 crore. Lord Goldsmith, it was 10 million rupees.
I never understand this.
Yes, they've reduced it to 3 lakhs. And now the bar tells me that the commercial courts are going to be flooded with litigation. And because now what's happening is virtually every civil dispute is a commercial dispute. That was not the intention. So maybe they should rethink that. And another colleague of mine told me that the important section on data analysis has to be there. The courts must give data as to how many commercial suits have been instituted, disposed, and so on. This data analytics will be a great benefit. And to give one example, Justice Lokur told me that they collected data on what are the arbitration appeals pending, and they found it said about 10,000 appeals pending. Surprisingly, a substantial percentage was from Haryana, which is not really a commercial center in that sense. Gurgaon is there, but large number of. So depending on the data of where the disputes are there, you could perhaps pigeonhole or place commercial courts in those states. So once you get into this data training, I think the system would be in much better shape.
Okay, right, interesting.
And now one thing, the other thing people told me here was that the major problem was, at least in the High Court, on recording of evidence. Here what happens is, now the system is, when the issues are framed, the matter is sent off to the master to record evidence. In some courts, they engage counsel to record evidence. And senior members say that's not satisfactory. The judge must see the witness. He must see the demeanor of the witness, the answers he gives, and so on. So how is, there's one proposal that they should make transcription mandatory. What's the position in UK? Is transcription mandatory, or you still record evidence? And you'd also, I've heard something of front loading of cases, so that when the matter comes to court, it's almost like a pre-cooked food, so to speak, and the matter is ready to go. Could you just throw some light on that?
Okay, these are 2 different things. I mean, okay, so English courts have always recorded evidence by, generally the witness would give live evidence before the judge generally, and the judge would take a note of it and of the cross-examination. And it would be in the judge's notebook, and he would have regard to it, no doubt, when he gave his or her judgment. And if the matter went on appeal, occasionally the appellate courts would have the judge's notebook, so they would see what he had recorded. Then, but we've moved to a practice where this is normally transcribed. It's not mandatory. A direction will be given normally at a case management hearing. So we say there's the classic position nowadays in a commercial case, and actually in other cases in the High Court too, there will be case management hearings. That's actually a key part of how these things are made efficient. And one of the things the case management hearing will do, one of the things will be to consider who's being called to give evidence and how the evidence is going to be recorded. So the evidence is generally recorded on a transcript, and the slightly old style fashion is there would be a shorthand writer who would take a note of it and then transcribe it, and then provide that at some later point to the judge and the parties. But it's possible now to have simultaneous transcription of evidence. There are a number of firms that do this. And the result is that you can be sitting with your computer screen on your desk. The witness gives an evidence and the answer comes up on the screen straight away. And you cross-examine and the answer comes up on the screen straight away, so that you can instantly go back to examine an answer that has been given by a witness. I think that's it's very efficient. You don't have, as I recall, we used to have sometimes we'd have a debate and somebody would say, well, as the witness said X, Y, or Z. And the other counsel would say, no, he didn't say X, Y, or Z. He said A, B, or C. And the judge would say, let me look at my notebook. And he'd say, well, I think he said D, E, and F. You don't have those debates because it's all actually recorded. It has additional costs and inefficiencies, but I think it's very efficient. And as a counsel who still does a lot of examination and cross-examination myself, it helps to keep up the momentum of a cross-examination because you're not stopping to wait for the judge to write it down. And I have to say this, I've had experience of the recording of evidence in India in an arbitration context, where I noted that what happened was that the evidence was given, the witness said something in answer to a question, and then the tribunal was reading out, right, well, we've written this down and as what the witness has said, and there'd be some little debate about what the witness said, and then you move on to the next question. I find that an extraordinary method of dealing with it because it loses the whole momentum of a cross-examination, which is designed to sort of get at the truth. Now, maybe it was an unusual experience. That may not be the way that it normally takes place, but if it is, I would very strongly recommend that you move away from that system because it seems to me to be not a great one. Anyway, that's so I don't know if that's answered the question about the recording of evidence.
I said on front loading of the cases.
Oh yes, you did. Okay, so one of the things that the commercial court did was to be at the forefront of innovation in court process. One great commercial judge, for example, Mr. Justice Matthew, he started a process on cases which really turned on a relatively simple thing. He would get the parties to agree the facts, and then there'd be no pleadings at all, and they would just turn up in court and argue it, and he'd answer it. But that would be something like, what is the meaning of this clause? Did force majeure apply in these circumstances? How much has to be paid? Something like that. So the commercial court started that, but we had more bigger reforms, which were the reforms many people will know about under the name of Lord Woolf, which has resulted in front loading of cases. And that means that more and more things have to be done before the case gets to court, so that by the time you get there, you've got the evidence in writing, you've got discovery has all been dealt with, issues have been identified. That means that there are fewer surprises when you get to the hearing, but it is an expensive process because the front loading means that parties have looked at the issues, the judges have looked at the issues before it ever gets to court. And at the time this change took place, a number of people, particularly, for example, solicitors firms who used to act frequently defending for insurance companies, they said, actually, this will be too expensive. Let the cases get to court because most of these cases settle, so much of this expenditure will never be needed. But I think in big cases, it's actually essential to do a lot of this. So that's what so I'm going to turn the tables at this fireside chat. By the way, when is anyone bringing the whiskey, Mr. Bachananda? You are in charge of this fireside chat. We have to manage ourselves.
It's lunchtime for you, so no whiskey.
No whiskey, not quite even lunchtime yet. So let me turn to you, Mr. Bachananda. What are the tools that you believe the Indian commercial courts can take to expedite resolution of commercial disputes? Are there provisions, for example, like early case management conferences I've just been trying to describe in the Indian Commercial Courts Act?
Yes, sir. And I think as a general sort of observer of the manner in which procedures have been altered for commercial courts, a general observer who saw the system internationally before the Commercial Courts Act came in India, I think there is a conscious attempt to follow the manner in which commercial trials are conducted in England. I think there is a conscious attempt, and I think there is in our procedural provision there is scope for example, a case management. It's not scope actually; it is mandatory now to have a case management conference in a commercial dispute. In which all timelines for, as you mentioned, front-loading the system, disclosure of documents, witness affidavits, all timelines are fixed in a case management conference. And the expectation is that based on a case management conference, the trial will proceed and get concluded in a time-bound manner. And I think that a proper use of a case management conference by the presiding judge is of immense value. It's of immense value. It sets the stage for a proper trial. There is now, the case management conference requires the fixing of a calendar for a day-to-day recording of evidence. One of the things which was most unsatisfactory in trials before civil courts was that you would examine one witness on one day and the other witness may turn up after 10 days or next month. So that, there is scope for having a composite fixed trial emanating from a case management conference. I think there is greater recognition of filing pre-hearing and post-hearing submissions. That was a practice that has developed had developed even before the changes in our Code of Civil Procedure based on the Commercial Code Act. But the culture of having, let us say, skeletal submissions or giving pre-hearing submissions where the judge has an idea as to what is the oral submission all about, has really picked up after the introduction of the Commercial Code Act. It has also facilitated in some kind of restriction in oral arguments. So they are more time bound in that sense. And I think there is one of the most powerful tools under the Commercial Court Act, I now think, is the Order 11, which relates to disclosure and discovery of documents. And it requires parties to disclose all documents which are relevant, whether they are adverse to you or in your favor, at the commencement of trial. And barring rare exceptions in which, when you are able to explain as to why certain documents were not produced, those are the documents that you go to trial with. And the provision on discovery is pretty much similar to the provision in England, in the sense that if you do seek discovery of a particular document, then the test is that it's either a document which is in your favor or against you, or will lead to a trail of inquiry that concludes in one of those outcomes. So in that sense, I think there are, I can talk of these 2-3 tools which I think are of great help before commercial courts.
So do you have post-hearing briefs then? Is that a common practice?
It is. And to be very honest, post-hearing briefs were fairly common even before the Commercial Courts Act. I think what is most impressive now is short pre-hearing briefs, which help the court focus or keep the counsel focused during the oral hearing. And then they have the comfort of being being allowed post-hearing briefs as well if they want to make a point in writing. But I have to say, sorry, sir, you were saying something.
No. I worry about post-hearing briefs. I think it's useful If a judge wants some detailed submissions on a particular point, that's fine. But in arbitration, which I do a lot, for example, it's almost inevitable that there will be a hearing brief. So the hearing concludes, you then have 3, 4, 5 months, and then a post-hearing brief, by which stage you've forgotten, the arbitrator's forgotten what was going on. It's all then regurgitated, frankly, sometimes, and the client is paying for all this. What I try to do is always to insist that when we get to the end of a hearing, we have oral submissions. Maybe you take a day off to prepare, but then you have the oral submissions. Your tribunal remembers what it's all about, I hope, and can ask pertinent questions. And then, from a counsel's point of view, you then have the advantage that you can then package the papers together, put them to one side, go on to the next case.
In most cases in commercial courts now, I think post-hearing briefs are often subject to detailed orders or guidance of the court, and they would just say restrict to the points that were made in court, and if you want to elaborate on them. And often they would be subject to a very short timelines, because by that time the judge who has heard the matter at length is also very keen to go on and start writing his judgment. So often they'd be subject to very strict and often short timelines. But I wanted to move on to another question. Sorry,
one second. To answer Lord Goldsmith, my limited experience was that the post-hearing brief is not actually a hearing, in my experience of the whole thing. They tell you that they just want clarification on 2 points. Typically, it could be on computation of damages, on cost. So yes, out of 7 issues, there'll just be 2 points on which they would want a post-hearing brief. So sometimes it does help, I thought.
That's fine. It's when you have, which I experience, suddenly it starts right at the beginning again. It's like nothing's ever happened.
That's quite problematic. That's quite problematic. So I wanted to ask a question to Justice Paul, and which is I think more from a policy perspective and the objective of our commercial court system. And I wanted to ask him if we should look at arbitration as an alternative to our commercial court system, because at least before the introduction of the Commercial Courts Act, the effort was to look at arbitration as an alternative to getting commercial disputes decided by civil courts. But now that we have the commercial court system, should we still look at arbitration as an alternative to the commercial court system, or should the two systems develop in parallel so that they're equally robust and complement each other?
Well, I feel both have to work together. Let's look at the problem we face. The first problem we had was in the arbitration side. We had a comparatively archaic act and the arbitration system not working well, despite being geared towards commercial resolution. And we had the Civil Procedure Code with its problems, where despite amendments, things were not working out. So let's look at both advantages and disadvantages. And I would say it will depend on the nature of the dispute and what the litigant wants. So from opting for an arbitration point of view, the first thing I would say is, look, you are talking about trained judges for commercial dispute resolution. When you take an arbitrator, he is a trained person of that field, and I am presuming that a trained person is appointed, not anybody. He may be a judge, he may be a commercial man. That's the advantage. Then in the system which we have now, the tiers of scrutiny, in some way, I would say not the number, but the scrutiny becomes less. So if an arbitration award is there, we had earlier practice of consistently a lot of interference from courts, which is, I think, considerably reduced now. And so awards are being accepted. That once you choose a judge, he's a sovereign judge, you must accept what he says, unless there is some really serious issue which needs. Then in terms of litigation cost, with the Schedule 4 coming in, there's more structured litigation cost to arbitration. And the arbitration award can be enforced as a decree of the court. It's not like the original times where it would be another second round before anything could be done. But it still requires an assistance of the court, let me say, in some way. And in commercial courts, there are some kind of nature of issues which can be better addressed. So let us say an aspect of interim relief before commencement of arbitration. Now that's a concern in terms of time consumption, and a lot of them arises, which the commercial court can directly address. If something happens, or if there are issues on the appointment and replacement of an arbitrator, I'm talking about things which can take time. Then the extension of time period for conducting arbitration proceedings, determination of appeals from certain orders of the arbitrator in between. Then finally, the enforcement of the final award. So there are aspects where the commercial court could have an edge, and it certainly has an edge where there is a precedential value. An award will not have a precedential value. So suppose you are settling a legal principle which has a larger ramification than the given facts of the case. That advantage a commercial court has. And in terms of the secondary but important issue is cost. All said and done, the cost in commercial courts would be far more reasonable, taking the court fees which is payable as compared to an arbitration award. There are caps on the court fees which are payable. There's a percentage. And on the lighter side, the legal fraternity also seems to charge more for an arbitration than appearing in commercial courts. So that's another addition to the cost which occurs. Another factor I feel is often that the commercial courts has the advantage now of a compulsory mediation. I have been, along with Siddhartha, a great votary of mediation. I believe in the Indian context, a lot of cases, commercial litigation in India is both pure commercial litigation or family commercial litigation. A lot of corporates are held within the family groups. So it's a flow from that family dispute which becomes a commercial dispute. And sometimes the objectivity in those issues are lost. So mediation takes care of the family element of the commercial dispute. I would not take, give an example, but I've seen as a judge very, very contentious matters when referred to expert mediators. They've been able to unlock it from that point of view of where the personal issues was coming in. So you have the concept of, say, something like a MEDA. Now, that's an issue which is catching on. My only reservation I must express again is that I feel the mediator and arbitrator should not normally be the same person, because arbitration is adjudicatory in character. Mediation is settlement in character, and before a mediator, you have a tendency to open all your options and all your positive and negative points, which in a litigative system, the lawyer would not let you open. So maybe a system, especially in where a part mediation takes place through a nomination and then the arbitration takes place, works better. Similarly, in commercial courts, the court holds over and says, okay, try in mediation. And to my view, this is an extremely, as I said, important avenue for resolution of disputes in family-oriented business disputes, which are a large number in India. The businesses traditionally in India have often been family-oriented till more recent times. Then you have, whether you call it commercial, it's the real estate disputes which are substantive in character. We have far more attachment to real estates than some of the Western countries, and we tend to keep those attachments and other plays into it. And those are aspects which are, I think, better determined in an arbitration, a MEDA situation, or in a mediation plea, a commercial court. So I think all mediation, arbitration, commercial courts, with the volume of litigation we have to hold, all will have a play. And I think the judge must be trained, if you ask me, should be trained as a mediator, should be trained as a commercial court judge, should understand arbitration. Then he knows which case has to go where. Personally speaking, when mediation started, I sat through the mediation training with lawyers to do all their courses. And I thought it helped me tremendously as a judge. Forget as a mediator, it helped me as a judge to understand what stage which case can go to mediation. So I think in the training system, when you are saying commercial court judges being trained, I think those commercial court judges should be trained in mediation, should have the fundamentals in arbitration, and should understand mediation. Then only a more holistic view can be taken, and it can work better in the Indian context. Mr. Datta, you are on mute.
No, I just muted myself because of the bandwidth. No, sir, you've been a great votary of mediation. And in fact, Madras High Court started the mediation center with Justice Karju. And we were trained initially. Sriram Panchu was the main person with us. One unfortunate thing in the Act, if I may say so, perhaps the government should rectify, is Section 12A talks of pre-litigation mediation. I don't see why there can't be mediation after the litigation starts. And in fact, sir, when the trainers came to Madras High Court from the US, I don't know what's the practice in UK, Lord Goldsmith can perhaps tell us. But in the US, I was told in at least the state of Washington and some states, once the issues are framed and the matter set to trial, there would typically be a gap of 12 to 18 months before the trial really started because of the pendency of cases and so on. And I believe there was a rule that you would have to take a chance. You are mandated to try to settle the dispute on mediation, because once the issues are settled, the discovery is over, all the things are over, and it's the right time to take one shot at it and try to resolve. And they said that you may not resolve all the 8 issues. Out of 8 issues, 4 issues may be resolved in mediation and only 3 are given to the judge to settle. So that was a good process. Maybe 12A can be amended and not just have pre-litigation mediation, but even post-litigation after issues also, before the matter goes, we could think of that as a mediation. And he's rightly put it, corporate mediation is very important, because now what's happening is in the NCLT, where all the jurisdiction of company law is there, the time is taken off by IBC cases. There's virtually no time for an operation mismanagement case or a typical corporate family dispute. So there, all the more reason we should think of a mediation process. And the other thing I want, sorry.
Sorry, only Mr. Datta, to just update information. See, one is that there is a Mediation Act, we thought, the MCPC, which is the apex body of mediators in the Supreme Court, which is headed by Justice Narman. We got the mediators going to frame a possible Mediation Act. We took assistance from the US, and that it's like a suggestion which has already been made to the government, and I suppose it is receiving the attention of the government. The other issue which you said on, I had an opportunity at some stage during exchange programs to go to the US and simultaneously travel to the UK to see actually how mediation was working in both the places. You are absolutely right. The very important issue is a mediation post-institution of the dispute also. So my personal experience of sitting on these litigations, because Delhi High Court, we had the benefit of the original side. So I sat almost for 2 years in different capacity on the original side. I used to find, for example, post-framing of issues is a very important issue. Matters are crystallized, documents have been filed, what issues have to be decided. So before trial and post issues, personally, I would refer disputes to mediation after framing of issues and pre-trial, telling them that, look, but by fixing dates of trial. So trial will commence 6 months hence. Now you have a window of 6 months to resolve the disputes. On shortening of the issue from the instruments, Gaurav said, very important issue is recording statement before issues. So I would often call the parties, whether I recorded statement or not, I would call the parties to be there and try to iron out and see if we can lessen the issues instead of very, very long-winded issues. So you are, ultimately, I feel a judge has to narrow down the issues and strike at what is where it troubles the parties, which is a mediator does, which an arbitrator does, while the adjudication we do it. So if we go stage-wise, I think a stage of narrowing the dispute with issues, referring it to mediation, trying with fixing a dates of trial, and this is something I personally imbibed when I saw the US system working, as you said, which works extremely well. So I think the mediation, pre-litigation mediation and inter-litigation mediation also, both are equally important, because sometimes the initial fire in you has to go out with filing the litigation. And once some midterm measures are done, and then maybe people are a little more amenable to. So it depends on case to case, I would say.
Yes, and I think after spending a lot of litigation fees, and you're more prone to settle the matter, I think.
You also get a refund of the fee if you settle. So part of the fee is funded.
Yes. Lord Goldsmith, what's the mediation position? I was told in the UK, if you refuse to go for mediation, you won't get the cost. That's what I was told by the trainers. I don't know if that's...
Well, I mean, there are different things. I mean, certainly mediation is important. All forms of alternative dispute resolution are important, and you're likely to be asked, at least at a case management conference, by the judge, have you attempted mediation? And might then impose an obligation to do that. And if you fail to do that, yes, indeed, there may be consequences, though difficult, because both sides sort of will have to appreciate that and agree to it. I don't understand, though, I must say, the idea that you can't mediate after litigation has started. It's often after litigation has started that the parties really start to realize what the problems are, which is why so many cases we find settle, as we say, at the door of the court, because it's only then that people realize the trouble they're in, or that actually their case is not as strong as they hoped it was. So it is valuable to do it before. I must say, I also agree with Justice Call that family disputes, and we have some of those too, property-related family disputes, then mediation is classically used quite often to try to resolve those. But there's one feature of mediation, I think, which sets it apart from court process, and that is is particularly apt in the context of family business disputes, and that is the ability to decide issues outside those which are actually the subject of the litigation.
Yes.
The litigation might be about a particular event or the ownership of a particular company or something like that. Actually, the real problem may be much more deep-seated, and the way to resolve it may be to have a restructuring of the whole family relationships or finances, or it could be the same in a company context, though families particularly have these issues. So I think it's a very valuable one. I've just been involved in one where these are exactly the issues that need to be decided. A judge could never have said, well, why don't you think about this or that, or providing, I'm not going to go into the details, of course, but they were outside the ambit of a court. So I think that's one of the advantages that mediation does provide. And I suppose the other is we're all aware of clients who don't want to talk settlement because that makes them look weak. If I'm the first one to pick up the telephone and say, would you like to settle this case? Aha, that means you're weak. You don't think you've got a good case. But if you're told you have to, then neither side picks up the telephone, as it were. Both sides have to come into that discussion, and therefore they can get over that, looking weak problem. So I think it is a very valuable addition, and I'm very interested in what Justice Call said. We also in the UK have learned a lot from the US experience and the Australian experience. There's a very strong mediation learning in Australia as well. So it's very much here to stay. But I would not say the moment the writ comes out that closes the bar, that puts the portcullis down on mediation. That would be my view.
This call, I also wanted to ask you, the present Commercial Courts Act, do you think it has cast the net very wide? Because they brought in all kinds of matters, admiralty, trademark, virtually except a property dispute or a partition dispute, everything is covered. Would it be better as a policy decision to taper it down to fewer matters, higher stake matters, so that the commercial courts start functioning much faster in really important disputes, which are related to the ease of doing business in that sense, particularly international matters?
I would totally agree. I think the net is too far wide of commercial disputes. One, subject-wise. Number two, the net is too far wide, as you said, on the valuation basis also. So on both sides. Now we have also the additional development in terms of some of the tribunals, which before we started being abolished, and that were coming in. So the whole debate starts as to whether you should have different specialized tribunals or everything should be brought into the main system. Now, my own view, I have been very, very circumspect on a lot of tribunals. Some tribunals have worked well. Your field, for example, tax tribunals have worked well. But there are a lot of tribunals where it's not worked so well. And one of the reasons, frankly, which I feel is that it's not the expertise of the person which is making them get appointed to this tribunal, whether it's part of the administrative tribunals or the judicial tribunals. So we are not picking up people in the specialized field to do that kind of work for which the tribunals have been set up. We pick them because they are available, or for reasons best left unsaid. So I've said in open for us that what happens is that these becomes a heaven for retired judges and retired bureaucrats who are not otherwise busy to get. And that's not something desirable at all. So tribunals and specialized places only work if you have people who have expertise in that subject matter sitting on it. For example, an IPR tribunal. If somebody who's never done IPR ever in life, to ask him to develop that expertise in your 60s is difficult now. As it transforms, some kind of subject matters are more area-centric. So for whatever reasons, IPR, I know almost 70 to 80% work got generated in Delhi High Court at some time. I don't know the figure currently, but when I was there. And it was more concentrated in Delhi, Mumbai, Chennai. These are the places where Similarly, with commercial disputes will be far more. So there are a problem like in Tamil Nadu, I was told that there are some courts where one judge sits for 3 districts as the commercial judge. This is happening because there's not enough work generated in that one district for that judge. So these disputes are also centric to the place where such disputes arise. So maritime law cases will arise in Mumbai, Chennai, or Calcutta. People will be more familiar there. But there also it is more because of the pendency of the original jurisdiction. They're far more centric to the high courts rather than to the district. That's one issue I think which needs attention. And therefore, mere always the same reason, increase the strength of judges will not help. This is the expertise of the judges. Expertise of the judge in the field he is handling. So in some areas, for example, when I was in Punjab, Haryana, being a land area there, a lot of disputes of land are far more. So people, while making appointments, the judges would tell me, pick up people who are centric to deciding that. Similarly, in Delhi, you would have to pick up people centric to deciding commercial disputes. My own view is that Chief Justice of the High Court must spread the net wide to pick up people from different fields, and there should be specialized jurisdiction in the High Court to deal with people who have expertise. So you can't have only general practitioners, you have to have practitioners from different areas and different fields practicing who may have now been practicing before tribunals, and with evolution of tribunals will be back in the High Court. So when you talk about expertise, the commercial litigation itself has various nuances, and all those nuances can be met if you pick up the best people from different fields to be appointed to handle that jurisdiction.
I want to ask Justice Goldsmith a question. Lord Goldsmith a question. In England, suppose
I never took the job. I never took the job.
No, suppose you had become a commercial court judge, hypothetically. In England, is it possible that you be shifted to the probate division or to the tax chancery division? I mean, I saw your divisions on the website. So if you're in the commercial court division, because in India, the judges would do tax matters and after 6 months go to the original side and so on. So what's the system in England?
No, you could be assigned to more than one list or given a sort of ticket to try those cases. I mean, for example, our High Court judges will normally spend some part of the year sitting in criminal cases because those are important, and so the most serious ones are still tried with a judge and jury. So they may try those cases. We have a system called assizes. I think there was such a system in India once upon a time. I don't know whether it still exists, but where people would actually travel around a part of the country trying the cases there, as used to be the King's justices would do that. So they may spend a part of their time doing that. They may spend a part of their time in the administrative court. So there is a degree of moving around, but it would still be because they have that judge, he or she, does have a particular qualification to do that. In the commercial court, the judges will only be judges who do have experience and expertise in commercial matters. The business world would not put up with it otherwise. And the English courts still do remain a popular court for many business people outside the country, and that's quite important. When I was, the centenary of the commercial court took place in 1995 when I happened to be chairman of the English bar, and so we did a little exercise at that point, not hugely scientific, but we took the cause list for the court for that day, or for a day, I forget which, but and we discovered that over 80% of the cases had at least one foreign party involved, and 50% of the cases had no English parties involved. They were purely between foreign parties who'd chosen English law, chosen to come to the English commercial court. I like to think it was, or we like to think it was partly because of the expertise that the judges offered in commercial law, at least perhaps compared with some of our European competitors. So I think that expertise remains critically important. The processes in court matter too, but the most important, I think, is the expertise. So judges may be, to answer your question, may be dealing with different cases at different points, but only if they've got the qualifications and expertise to do it.
That's important, I think. That's important because there's good. Lord Goldsmith said that it's if you have specialists dealing with specialized fields, that's the only way to produce that. Everybody cannot be a specialist in every field. You can't be a master of all.
Exactly.
Be jack of all trades, not the master of all.
Exactly, sir. You're on mute, Mr. Pachananda.
There are so many questions that I had thought that I would put to my fellow panelists today, but I'm being reminded that we are sort of close to the time constraint that we have. So I would, if you permit me, I have just two last questions on which I would address the second last question to Mr. Datar, but I would then welcome the comments of Justice Kaul and Lord Goldsmith on that. And I will address the last question to Justice Kaul, which I think is something on which I would again request the other two panelists to comment. My question to Mr. Datar is that there is a view in India that a large volume of work before commercial courts still relates to applications and proceedings arising out of arbitration. And as a result of that, really commercial courts are doing very little original side work. Based on that situation, do you think that there is a case for dividing commercial courts into arbitration courts and original side commercial courts or something like that? Or do you believe that this is an inevitable outcome of the manner in which commercial litigation and dispute resolution happens in India, because a large volume of it is in arbitration, and there is going to be a consequent fallout of that in the commercial courts as well?
Well, Gaurav, that's actually it's actually a part of a problem, and it's also a blessing. Earlier, when we did arbitration and succeeded in arbitration, after the arbitration was over in 3 years, we would again perhaps be stuck in a Section 34 proceeding for 3 to 4 years. So one major problem was that after getting the award, we're going to again wait for 3, 4, 5 years to get the Section 34 decided. So now that the commercial courts have come, the disposal of Section 34 has increased. At the same time, it has elbowed out other kinds of litigation. So in some courts, the commercial court virtually is an arbitration court. I mean, there are two courts. One court is a Section 9 Section court, and the other is a Section 34 court. And in some cases, the division bench is a Section 37 court, appeal court. So virtually the entire thing is monopolized by arbitration in many courts. And for example, I have not heard of a case where commercial court has taken a patent case up to trial or taken an admiralty matter, because they're very public. Yeah, I think the answer at the end of the day is just filling up all the vacancies and filling up with trained commercial people. If we have got some 300, 400 vacancies, if the vacancies are filled up with commercial people, and then you have dedicated time, maybe in the years to come, Justice Kaul may, at the Supreme Court level, they may think of a policy view where high courts have a commercial division, they have a chance to like a tax division. Commercial division of 5, 6 judges can handle not only arbitration work, but also other commercial matters. And I think essentially it's better to narrow down what is the commercial court jurisdiction and not include everything else. Like, there's no need for IPRs to be in the court. When I was a junior, the trademark patent was done by the original side judge. It cannot be a commercial court. I think there is a disturbance. Thanks, Gaurav, for the entire evening. Thank you so much.
So I have just one more question for Justice Kaul. And I think that is a question on which I would, after Justice Kaul, perhaps invite comments of the other two panelists as well. And my question is that based on your experience, sir, do you believe that making changes in the legal framework or the procedural law in the commercial, with respect to the commercial court system is enough? Or is there a need for something beyond that, in the sense that a cultural shift in the mindset of lawyers, litigants, and the judges who approach the commercial court system for dispute resolution? Because as a trial lawyer many years ago, when I started going to the law courts, I used to get a sense that if really a judge wants to expedite a trial, and if the counsel on both sides really do not want to delay the matter, there was enough scope, even in our unamended CPC more than 2 decades ago, to expedite the trial. And I'm just wondering whether one of the issues that we really need to focus on is a cultural shift in the mindset of stakeholders in the system to make these systems work.
Gaurav, before I take up this issue, just one first comment on what Mr. Datar was saying.
Yes, sir.
I believe that if you have different jurisdictions in the commercial court area, then each court must study in which particular branch of commercial court are there how many cases. So that parallelly all different kinds of cases go on. It's the same way as you have a large load of work, you feel old cases must go on, medium level cases must go on, current cases must go on. So similarly, I think some court management is required in that way. Similarly, I'm linking it because if you come to the current scenario of how it is done, and yes, I have held the view that if the judge is firm, the lawyers abide. Unfortunately, that's the reason. So, but one of the greatest challenges is that the number of cases are so large before a judge that willy-nilly a number of them get adjourned. So it's a question of how the lawyer who's wanting an adjournment structures the thing, knowing fully well that there is a grave possibility because some other case will start. Which is what again brings me to a court management system. I have continuously advocated that even if you are giving a longer date, it is better to give that longer date and a fixed date when you can pick it up rather than just rolling over the cases. Now, if that is attended to, I think the mindset of the litigant and lawyer can be changed. Invariably, in the Indian context, one or the other party will find it is not so convenient. We amended the Civil Procedure Code. We said file the written statement not beyond this time. We again found avenues how it could be filed. We are honestly we are too liberal on time period. We are too liberal on limitation. We don't think that the discipline of time is given an importance. We forget that the discipline of time or limitation in case of an uneducated person who is a villager or in a criminal matter is different from a commercial matter. When you're dealing with a commercial matter, both people are supposed to be of commerce, must know the time schedules, must adhere to the time schedules. So the judicial approach to time frames has to be different, I think, for a commercial matter. So far as the bar is concerned, yes, I think this whole concept has to change that getting an adjournment is like some kind of a birthright, I think. It's completely unacceptable to a lot of us. And frankly speaking, as a lawyer, I used to find it very irritating. That, you go prepared for a case, you'll get adjourned because somebody else will seek a passover on the first call, which is almost by the time the second call doesn't come. So a holistic change is required. We have to mean business in it. Now you take it back further, I think education of lawyers becomes an important aspect. So control of the profession becomes an important aspect. Maybe education, it is control of discipline. It's so many factors of training which are required so that the lawyers mean business when they get there. And I think in a commercial disputes, which is the subject matter we are dealing with, it's all the more important.
Mr. Datar, your comments on cultural shift?
No, yes, it is indeed important because actually we should take adjournment for taking for granted. And then now we know that it can't be done. Time is extremely important. That's very, very important. And what lawyers don't realize is that when we went for training for mediation and so on, you don't realize that the faster number of cases you dispose, more work is going to be generated for the lawyers. See, the point of in India is not the areas. Justice L.P. Sinha in one conference at the National Judicial Academy said that what is more dangerous is the number of cases filed per million people. Fewer people come to court because today if I have to get 4 lakhs of rupees, it's virtually impossible to file a suit and get a degree in 3-4 years because of the limitations. If we have a discipline and we'll go faster. In fact, to answer Justice Kaul's question also, when I was Madras Bar Association, very old trial lawyer, and he said if you just stick to the timeline mentioned in the CPC, no case should take more than 1 to 2 years. If you just stick to the timeline, there's no need of any great reform. Just follow what the CPC says, and there's no question of any adjournment. The suit shouldn't take more than 2 years. Another thing is we have to really bring in the system of cost. Today, what happens is you see in the Supreme Court or High Court, everything is there's no order as to cost. Person could file the most frivolous case, make the other side engage counsel, time, money. Then so once there is cost, then you think twice about getting into court. So I think sooner or later, apart from discipline, we must somehow bring in the system that's maybe moderate cost, but at least cost should be.
We have to change this mindset that the cost is the reflection. You impose cost, and the lawyer feels you are
punished.
You're reflecting on him.
Yes,
not correct. This approach must change. That it's not a reflection on the lawyer; it's a reflection on the merit of the matter.
Yes, sir.
And cost must follow the result. I mean, there's general rule.
Lord Goldsmith, any thoughts on change of culture? Do you think that it's very important to have a proper culture for commercial courts to work?
I think it's frankly, it's important for all courts to work, but I must say I agree entirely with what Justice Call and indeed Mr. Datta have been saying. And I was struck by Justice Call's phrase, discipline of time. That's absolutely right. I mean, it's known outside India that the ability to adjourn cases seems to be so easy to do, and I'm afraid it makes the legal system almost a laughingstock that it's possible to do that. I think discipline of time is critically important, and we find that if you can agree and the judge imposes discipline, this case will take X hours, we will split the time, so you have 1 hour, you have 1 hour. When that time is done, you're finished. Other countries do this. I've appeared in European and international courts where at the end of the 30 minutes that I've been allowed, the judge said, stop. In the Supreme Court in the United States, there is a light which comes on that tells you you have to finish. Doesn't matter if it's the middle of the sentence. Now, I'm not advocating that, but it does demonstrate where you need to get to. And if the lawyers know they've only got that amount of time, well, they will use it as best they can. So I agree with what's been said. I think it's a very good moment on which to finish this excellent fireside chat.
Thank you very much. It's been a very interesting discussion indeed. It was not a part of our program to have any questions and answers, although initially we all thought that we will keep time for that. But it appears that the manner in which our discussion has progressed, that even that effort we will not be able to accommodate. But I just wanted all of us to part by making one comment, and starting with Justice Call. One thing, just one thing, and I think at the end of this we will have 4 comments. One thing which Justice Call feels is of prime significance, of prime importance that we should focus on in making the commercial court system work.
Well, you have told me one thing. I will take a cue from the country of the region of Lord Goldsmith. I once said that, there are 3 things from the British we should have imbibed. The first was sense of discipline. That's what is important for the commercial court to work. The second, of course, I said was being chief proud and country proud. And the third was a sense of humor. I think there are 3 things we learned from the British always. And the first one is what I think, if we work the system, whether it's the civil procedure code, whether it be commercial code, any of them, if we work within the discipline and time that Mr. Datta said, everything is possible. If we let it loose, then we have the same problem at hand as we had.
Thank you very much. Lord Goldsmith, one thing that we should focus on?
Well, one thing we should focus on that we haven't talked about, but which has been, I've seen at least one question have raised it, technology. There is an extraordinary article actually in today's Financial Times, an essay which talks about how technology has operated during the pandemic. But fusty old-fashioned lawyers that we all are, I think we've all done really, really well on technology. There is Justice Call sitting in the Supreme Court, though he's not there at all, and his colleagues, and getting on with the business of justice. And all of us have managed to do it. So we've even managed to organize this to go to the fireside chat. So I think there is an issue there about technology, which the courts and the lawyers need to keep working on, because that is a way, undoubtedly, of improving efficiency. And the pandemic, terrible though it is, shows that if we have to do it, we can.
Thank you very much. Mr. Datta, one point that you'd like to make?
Having heard all of you, I think just as charity begins at home, I think the solution must begin at home. It's very easy to blame the system, say there are no specialized judges, there are too little judges. I think as a council, I think we should perhaps take a resolution that we will be as brief as possible and as disciplined in our arguments as possible, and not just take endless amount of time. So unless we resolve ourselves that we will be brief, we will be precise, and we will not take an adjournment unless it's absolutely imperative. I think that will also make a great difference.
Thank you very much, sir. My point would be that I think
yes, what is your point? Yes.
Yeah, my point would be that we need, given the wealth of talent that we have in the commercial bar, I think we need to look for innovative ways of making the commercial bar contribute toward the strength or the bandwidth of the commercial court system. in innovative manners and also making a sacrifice for greater public good, so that the aspirations of both sides are met. And I think short-term commitments may be a good idea, which need further discussion. Thank you very much. We've had a very interesting discussion. As I said, I will apologize to the participants who've sent several questions that we've not been able to take, although our effort was that we will try to accommodate them. Perhaps we will use the good offices of our webinar secretariat, Lex Witness, and try to answer as many of them offline as we can. Thank you very much, Justice Call, for sparing the time and contributing to these discussions. Thank you very much, Lord Goldsmith. And Mr. Dattar, as always, thank you very, very much. It's been a very interesting discussion.
Gaurav, can you please thank the entire team who organized it? They've done a marvelous job putting it together. So I think
yes, of course. Thank you. I need to thank the entire Nani Palkiwala Arbitration Center team for hosting and blessing and sort of promoting this idea, and also Lex Witness, the webinar secretariat that has helped us organize this webinar very efficiently, and also something that Lord Goldsmith said, technology. I mean, I was struggling with the technology of how this webinar has to be hosted, and they are the ones who just took it over and did everything for me. Thank you very much. Thanks a lot. Thank you very, very much.